Good afternoon, everyone, and thank you for joining us today for the Fair Lending and Consumer Compliance Regulatory Update webinar. My name is Ernestine Ward, and I'm a Consumer Compliance Policy and Outreach Program Officer in the Office of Consumer Financial Protection here at NCUA. That was a mouthful. Before we start, I want to just give you all some technical tips to make sure that you can see the console and hear the presenters in today's presentation. First, please make sure you allow pop-ups from this website. Second, if your display is not clear, set your screen resolution to at least 1024 × 768 in order to clearly see the webinar slides. You can also drag the bottom right corner to resize the slide view. We also welcome participants to submit questions during the presentation. However, we will not answer the questions until the Q&A portion at the end. In order to submit a question, please click Ask a Question on the left corner of the console window. Finally, in 3 weeks, a closed caption archive of this webinar will be available in our learning management system. I'm now going to turn it over to Matthew Baloris, the Director of the Office of Consumer Financial Protection, for his remarks.
Thank you, Ernestine, and welcome to all of you joining us today. I'm very pleased to share the stage with several members of our team in the Office of Consumer Financial Protection. Joining me this afternoon are Program Officers Ernestine Ward, who you just heard from, and we'll hear more from, Al Brantley and Matthew Nixon, who will share their perspectives on a variety of consumer financial protection matters. Also joining us this afternoon to help with the question and answer portion of the webinar is Joe Goldberg, our Director of the Division of Consumer Compliance Policy and Outreach. Each year, as part of the agency's annual performance plan, our team in the Office of Consumer Financial Protection highlights for credit unions some of the consumer financial protection related trends we're seeing in the agency's examination program, which includes our Fair Lending Supervisory Program, as well as results of the special consumer compliance review areas conducted by examiners during safety and soundness examinations. For some context, under the agency's risk-focused examination program, examiners are able to focus exam time on those operational or compliance areas deemed to be higher level of risk to the credit union. To supplement the risk-focused exam program, our office works collectively to develop a series of required consumer compliance areas of focus for examiners to review, in addition to the scope they develop for each exam under the risk-focused exam program. In developing these special consumer compliance review areas, we consider several factors, including but not limited to recent final rules, taking into account the applicable effective date of any rule, findings from safety and soundness and fair lending examinations, consumer complaints, and even areas of focus of common interest discussed with collaboration with our other federal regulators as part of the Federal Financial Institutions Examination Council. So this afternoon, our team will share some consumer compliance related findings from the safety and soundness examinations and fair lending examinations, and even tee up some emerging hot topics for discussion. While we had hoped to offer some insight into any likely areas of focus for 2022 during this webinar, we're still finalizing them, so it would be premature to address them this afternoon. However, those of you familiar with this process know the agency typically issues a letter to credit unions early each year to provide its supervisory highlights for the coming year, so be on the lookout for that through the new year. And before I turn things back over to Ernestine, I'd be remiss if I didn't take advantage of this opportunity and large audience to publicly express my deepest appreciation to Joe Goldberg for the significant contribution he has provided our office over the last near decade with us, most of that in a leadership role. Joe will be retiring at the end of the year. I know any of you who have had the privilege of working with Joe in any capacity share my appreciation for his thoughtfulness, leadership style, and accomplishments. Our entire team in OCFP wishes Joe all the best as he begins his next chapter in the new year. And with that, I'll turn it back over to you, Ernestine.
Thank you so much, Matt. All right, so first I'm just going to quickly go over our disclaimer. So the materials presented in this webinar are intended as an informative and educational summary of general information that's related to consumer compliance focus areas and fair lending. We have taken reasonable measures to ensure the quality of the data and other information produced by the NCUA that is available in this presentation. However, NCUA makes no warranty, express or implied, and does not assume any legal liability or responsibility for the accuracy, correctness, or completeness of any information that is available to this presentation. These slides are intended for educational and discussion purposes, and they do not constitute legal advice. All right, and our next slide is our agenda. So first, we're going to talk about some regulatory updates. Then we're going to speak about a COVID-19 interagency statement that was recently issued. Then we'll speak about the 2021 Consumer Compliance Exam Scope activities. And after that, following that, we'll speak about observations on the 2021 activities. Then we'll talk about fair lending topics. And we will then move into consumer compliance hot topics. And then after that, we will go into Q&A. All right. So moving along, I'm just going to discuss two important regulatory updates with everyone today. The first one is the rule removing the prohibition on capitalizing unpaid interest. So on June 24, 2021, the NCUA board unanimously voted to lift the prohibition on capitalization of interest in connection with loan workouts and modifications. So as we all know, capitalization of interest is the addition of accrued but unpaid interest to the principal balance of a loan. This rule gives credit unions another tool in their toolbox to work with borrowers who are experiencing financial hardship due to the COVID-19 pandemic and to help their members modify loans. Such modifications may allow a borrower to repay the loan, which helps the borrower and the credit union avoid the cost of default and foreclosure. The final rule also gives credit unions parity with banks, Fannie Mae, Freddie Mac, and the FHA, all of which already allow servicers to capitalize interest as part of a prudent modification program. Now, the rule also includes some important consumer financial protection guardrails that I want to go over. First, the rule maintains the prohibition on a credit union financing credit union fees and commissions. Second, the final rule requires credit unions to adopt policies and procedures to ensure that loan modifications are in the long-term best interest of the borrower. All documentation, including required disclosures, must be accurate, clear, and conspicuous, and consistent with applicable federal and state laws and regulations. And also, as a reminder, any adverse credit reporting related to this should be accurate and comply with the requirements of the Fair Credit Reporting Act, including the CARES Act amendments to the Fair Credit Reporting Act, and when applicable, state law. So on the next slide here, we just have a couple of resources. If you want to know more about the rule, these resources are both on our website. I'm sure you've already, many of you have probably received a letter to credit unions addressing this topic. And there's also some frequently asked questions regarding this rule on our website, which is available to participants. All right. Moving on, the next regulatory update I want to talk about is the 2021 COVID-19 mortgage servicing rule. On June 30th, 2021, the CFPB issued a final rule which temporarily amended certain mortgage servicing requirements under Regulation X, and this was to assist borrowers affected by the COVID-19 emergency. This rule took effect on August 31st of this year. Now, the final rule provides additional protections to borrowers experiencing a COVID-19 related financial hardship, and it includes 4 key components. The first is procedural safeguards. The second is streamlined loan modification options. The third is enhanced live contact requirements for servicers. And the last is reasonable diligence requirements for servicers who are working with delinquent borrowers. I also want to just mention some key points about the applicability of the rule. So first, the final rule only applies to servicers that service mortgages which are secured by a borrower's principal residence. And second, the rule does not apply to small servicers A small servicer, as defined in Regulation B, includes a servicer that, together with any affiliate, services 5,000 or fewer mortgage loans for which the servicer or an affiliate is the creditor or assignee. I'm now going to discuss the 4 key components of the rule. All right. So first, the rule requires servicers to observe special COVID-19 procedural safeguards before foreclosure referral. And this was really to ensure borrowers experiencing a COVID-19 related hardship have a meaningful opportunity to pursue loss mitigation before foreclosure referral. These safeguards apply where a borrower became more than 120 days delinquent on or after March 1st, 2020, and the statute of limitations for the foreclosure actions expires on or after January 1st, 2022. These safeguards sunset on January 1st, 2022, and as such, these safeguards only apply to foreclosure referrals between August 31st and December 31st of this year. So from August 31st to December 31st of this year, a servicer can initiate foreclosures if one of the safeguards that I'm about to mention are met. So the first safeguard is that the borrower was already evaluated for loss mitigation options. The second safeguard is that the property is abandoned. And the third safeguard is that the borrower was unresponsive to outreach. Okay. Moving along, another component of this final rule is that under the final rule, servicers may offer certain COVID-19 related streamlined loan modifications based on the evaluation of an incomplete application. And this is if specified criteria are met. So the loan modification program, it must meet certain requirements, and these requirements are similar to programs FHA, Fannie Mae, and Freddie Mac are offering. Oh. The final rule also temporarily modifies early intervention live contact messages, and this is to help ensure that borrowers experiencing a COVID-19 related hardship have timely and accurate information about their loss mitigation options. So the final rule requires servicers to provide additional information to borrowers experiencing COVID-19 related financial hardships. Now, these requirements apply to live contact made between August 31st, 2021 and October 1st, 2022. Now, the information to be provided by the servicer depends on whether the borrower is in a forbearance program or not at the time the servicer makes live contact. I'm just going to quickly mention the information that a servicer would need to provide to a borrower who is not in a forbearance program at the time of the live contact. Under the rule, the servicer must provide the borrower 3 pieces of info. And the first is that, forbearance programs are available for borrowers experiencing a COVID-19 related hardship. 2, a list and brief description of such programs and how the borrower can apply for these programs. Now, this requirement does not apply if the borrower states that they are not interested in receiving information about loss mitigation programs. And lastly, the servicer must let the borrower know of at least one way the borrower can find contact information for home ownership counseling services. All right. And lastly, the final rule, basically it clarifies a servicer's reasonable diligence obligations when a borrower is in a forbearance program made available to borrowers experiencing a COVID-19 related hardship. Specifically, the servicer must contact the borrower no later than 30 days before the end of the forbearance period if the borrower remains delinquent to determine if the borrower wishes to complete a loss mitigation application. If the borrower chooses to do so, the servicer must exercise reasonable diligence efforts to complete the loss mitigation application before the end of the forbearance period. Now, I want to just make a couple of points about the applicability of these reasonable diligence requirements. So they do not apply to borrowers who accept a streamlined loan modification. However, reasonable diligence must be resumed if the borrower fails to perform on a trial modification that's associated with a streamlined option, or the borrower indicates that they want to complete a loss mitigation application and proceed with the full evaluation. And also, just a quick note that the reasonable diligence efforts, these can be done in writing or verbally. All right. As you know, as you can see, the rule has a lot of different parts. So here on the screen are some resources regarding the 2021 COVID-19 mortgage servicing rule that you can look into to find out more information and the specific details. And so that concludes the regulatory updates portion of the presentation. All right. So next, we just want to mention a relatively recent joint agency statement that's related to COVID. So on November 10th, the federal financial institutions, regulatory agencies, and the state financial regulators issued a joint policy statement announcing that the temporary supervisory and enforcement flexibility announced in the April 2020 joint statement no longer applies, and the agencies will apply their respective supervisory and enforcement authorities where appropriate to address any noncompliance or violations of the Regulation X mortgage servicing rules that occur after the date of the issuance of the statement. The statement is there on the screen if you you can see it. The statement basically explains that more than 18 months have passed since the issuance of the April 2020 joint statement. And while the pandemic continues, servicers have had sufficient time to adjust their operations. The statement goes on to say that the agencies recognize the ongoing challenges faced by mortgage servicers and their efforts to assist customers and members affected by the ongoing COVID-19 pandemic. The agencies continue to encourage mortgage servicers to engage in these efforts, and the agencies will consider, when appropriate, the specific impact of servicers' challenges that arise due to the COVID-19 pandemic and take those issues in account when considering any supervisory and enforcement actions. And lastly, we would like to note that, as is our general practice, NCUA can consider a credit union's good faith efforts to comply when determining how to address any non-compliance or violations. All right, well, we are moving right along. So the next portion of our presentation, we're going to speak about the consumer compliance exam scope activities in 2021. So first, I'm going to review the scope areas. Then Al Brantley is going to discuss observations on these activities. And then we'll pass it over to Matt Nixon, who's going to discuss our fair lending activities and other related fair lending topics. All right. So on your screen here, you can see the different consumer compliance scope areas from 2021. So in 2021, NCUA examiners reviewed mortgage forbearances and other loan accommodations that credit unions provided to their members during the COVID-19 pandemic, as well as the credit unions' reporting of these accommodations under the CARES Act amendment to the Fair Credit Reporting Act. Now, the review focused on mortgage loans and non-mortgage loans, with the category of mortgage loans being divided into a subset of CARES Act loans and other mortgage loans. As you can see on the screen, there's kind of three buckets here. So we reviewed forbearances under the CARES Act, and those are single-family mortgage loans, and these are, these refer to federally backed loans, non-CARES Act loans, which are non-federally backed loans, single-family mortgage, and then also the non-mortgage loans, which include various types of consumer loans, auto loans, unsecured loans such as those. So the reviews assessed a credit union's compliance management system and ascertained whether credit unions were effectively managing the loan accommodation process. The assessments also included reviews of whether credit unions offered borrowers available forbearance options fairly and consistently, whether they properly handled documents submitted by borrowers experiencing financial hardships due to COVID, and then whether the loans were properly serviced while they were in forbearance. And also we reviewed, whether or not credit unions, did not mislead borrowers about any aspect of the forbearance or the accommodation. So during the onset of the COVID-19 pandemic, the federal financial institutions, the regulatory agencies, and the state financial regulators issued a joint policy statement regarding loan mods and also reporting for financial institutions that were working with consumers affected by COVID-19. And the intent of the policy statements was basically to help facilitate mortgage servicers' ability to make prudent arrangements to mitigate the long-term impact of COVID-19 on consumers by avoiding delinquencies and other adverse consequences. And these statements provided credit unions with regulatory flexibility and guidance relating to early intervention and loss mitigation. So in 2021, NCUA examiners took into account the unique circumstances impacting borrowers and credit unions resulting from the COVID-19 pandemic. And while considering the size, complexity, and risk profile, examiners also took into account credit unions' good faith efforts designed to support consumers and comply with consumer protection laws. Examiners provided feedback based on identifying issues, correcting deficiencies, and also ensuring appropriate remediation to consumers. All right, so now let's discuss consumer compliance activities for the CARES Act loans. As I mentioned, the CARES Act covers federally backed mortgage loans and borrowers who are experiencing a financial hardship due directly or indirectly to COVID-19. Under the Act, as I'm sure everyone on this call knows, borrowers can request forbearance by making a request to their mortgage servicer and affirming that they are experiencing a COVID-19 financial hardship. Servicers are required to provide a CARES Act forbearance and allow borrowers to defer their mortgage payment for up to 180 days and possibly longer. As we know, many of these agencies extended some of these forbearance protections. So for credit unions that service mortgages that were covered by the CARES Act, NCUA examiners assessed the credit union's compliance with the relevant parts of the Act. Now, this included, but wasn't limited to, verifying required notices that were given to borrowers who sought relief under the CARES Act, such as the 5-day acknowledgement notice that's given after the receipt of an incomplete application. And they also reviewed whether required actions were taken, such as sending an annual escrow statement. However, examiners did not criticize credit unions for failing to do so within the required time frames. Now, let's discuss the consumer compliance reviews of non-federally backed mortgage loans. So credit unions that do not sell their loans in the secondary market may have been able to kind of use creative, temporary, and permanent loan modifications to assist borrowers. Examples of temporary modifications used by credit unions include payment forbearance, waiving late fees, waiving modification fees, offering interest-only payments, also, a reduction in the interest rate. And examples of a permanent loan modification include consolidating a loan, extending the maturity date, forgiven principal, or various other restructurings of notes. NCUA examiners, assess whether a credit union considered a borrower's ability to repay the debt, particularly at the end of a temporary accommodation period, and especially if the modification resulted in a higher payment or a balloon payment. In addition to considering a borrower's ability to repay out the loan modification and prior to providing relief, examiners reviewed whether credit unions ensured that borrowers were aware of the terms of any modification and potential impact on their loan balance and future payments. All right. Now, reviews of consumer loans were similar to the review of mortgage loans in that examiners assessed whether credit unions' efforts were conducted in a reasonable manner with proper controls and oversight. Examiners determined whether accommodations were appropriate for the borrower's needs and degree of hardship, and whether the credit union made sure the borrower understood the terms of the modification and any future impact. Examiners also reviewed a sample of loans to determine whether credit unions complied with applicable TILA and Reg Z disclosure requirements for covered modifications. Examiners also reviewed loan documents to ensure that the modifications and documents didn't contain any unfair, deceptive, or prohibited provisions. All right. Now, here's another part of the CARES Act that we reviewed for. So Section 4021 of the CARES Act, it amends the Fair Credit Reporting Act to provide credit protection during the COVID-19 pandemic. Now, this provision requires credit unions to report loan accommodations resulting from the pandemic as current or as a status reported before the modification. So examiners confirmed that credit unions, were designating loans in accordance with this CARES Act provision, and also reviewed credit unions' procedures and controls for reporting loan accommodations to the credit reporting agencies. So that was that was an overview of all the the consumer compliance issues that were included in 2021. And on the next slide, we have some resources. This is pretty much some of the stuff that I've just mentioned. Most people may have already seen these, but feel free to look at them again if you wish. So thank you so much for your time. And now I'm going to pass the virtual mic on to Al Brantley for him to discuss observations on our 2021 consumer compliance activities. Thank you.
Thank you, Ernestine. This is Al Brantley. I serve as a program officer in NCUA's Office of Consumer Financial Protection. Consumer financial protection is a vital element of member service. Therefore, NCUA examines for compliance with applicable consumer financial protection laws and regulations during regular examinations. To recap earlier remarks, each year NCUA identifies specific consumer financial protection laws and regulations required to be reviewed during examinations when applicable to the credit union. We select priorities for a given calendar year by analyzing trends identified through examinations, member complaints, recent changes to regulatory requirements, and time since a law or regulation was last required to be reviewed. The scope of each examination's consumer compliance review is risk-focused, based on each credit union's compliance record, products and services offered, and any new or emerging concerns. Issues and violations are usually attributable to weaknesses in one or more areas of the credit union's compliance management system, or CMS. A robust CMS helps you manage risk with products and service offerings, as well as new laws and their implementing regulations. Non-compliance may lead to informal or formal administrative actions, litigation by affected members, and elevated reputation risk for the credit union. Compliance expectations also extend to third-party relationships. If you outsource the operational aspects of a product or service, you cannot abdicate the responsibility for complying with applicable laws or managing the risks associated with third-party relationships. Again, to recap, in 2021, NCUA examiners completed targeted reviews to evaluate compliance with the consumer financial protection areas listed on this slide: fair lending compliance management system and controls over disparate treatment, forbearance of residential loan mortgage payments made as a result of COVID-19. NCUA field staff looked at loans covered under the CARES Act as well as loans not covered under the CARES Act. Loan accommodations or modifications made for non-mortgage loan payments as a result of COVID-19, and credit reporting protections offered to members as a result of COVID-19. Since our time is limited today, I'm going to spotlight common issues and violations we've observed in each of these areas. We'll take a high-level look at each area to get an idea of what examiners have been citing and addressing during examinations. This knowledge is something you can't get anywhere else, and it could help you in preparing for your next exam. In this area, examiners found policies or guidelines that may be discriminatory or inadequate to ensure fair lending compliance. In some cases, procedures were non-existent or inadequate for responding to member complaints. In others, the compliance program was not subject to an independent audit or review, either by insiders or an external party. Further, some credit union employees had not received training on applicable laws and regulations. Weaknesses in a credit union's compliance management system may lead to violations or other compliance issues. Whether formally defined or not, a credit union's CMS is an integrated risk management system of written documents, processes, tools, controls, and functions to ensure the institution complies with applicable laws and regulations. It also helps credit unions better address training, communication, monitoring, and self-correction. Further, a strong CMS can minimize harm to consumers in instances of non-compliance or violation of a law or regulation. Even if CMS is not a targeted review area, examiners generally evaluate the effectiveness of a credit union's CMS during regular examinations. Their overall conclusions impact the credit union's final compliance risk rating and CAMELS ratings for the management component and composite score. In response to examiners' findings, the credit unions agreed to take one or more actions to address the issues. Depending on the facts and circumstances observed for a particular exam, management agreed to revise their policies and procedures, formalize their member complaint process, ensure appropriate staff receive compliance training, and/or expand the independent audit scope to ensure sampling or testing of consumer loans for compliance. As part of your overall CMS, you should have a suitable training program to ensure employees and volunteers are properly educated on the applicable provisions of the Equal Credit Opportunity Act, the Fair Housing Act, and other federal consumer compliance laws. So far, we have not observed any issues or violations with respect to single-family mortgages subject to the CARES Act. Applicable mortgages include those insured or guaranteed by HUD, Veterans Affairs, or USDA, and those purchased by Fannie Mae and Freddie Mac. Fewer credit unions offer these loan types. In some credit unions that offered COVID-19 related forbearance for other single-family mortgages, examiners found inadequate policies and procedures. Examiners also found the disclosures to members to be deficient in a few cases. However, the noted issues did not rise to the level of violations of the Truth in Lending Act, which is implemented by Regulation Z. In response to examiners' findings, the credit unions agreed to take one or more actions to address the issues. Depending on the facts and circumstances observed for a particular exam, management agreed to revise their policies and procedures and/or provide adequate disclosures to their members. As part of your overall CMS, you should have a suitable training program to ensure employees and volunteers are properly educated on the applicable provisions of any law, regulation, or related industry guidance affecting residential mortgage loans if you make these types of loans. Examiners found that many credit unions extended their skip-a-pay payment services to accommodate COVID-19 related relief for non-mortgages. However, the practices observed raised some of the same concerns as with the loan forbearances on single-family mortgages, as was illustrated in the previous slide. Some credit unions had inadequate policies and procedures and or provided inadequate disclosures to the borrowers. However, the noted issues did not rise to the level of violations of the Truth in Lending Act. In response to examiners' findings, the credit unions agreed to take one or more actions to address the issues. Again, depending on the facts and circumstances observed for a particular exam, management agreed to revise their policies and procedures and or provide adequate disclosures to the members. As part of your overall CMS, you should ensure that you have a suitable training program so that employees and volunteers are properly educated on the applicable provisions of any law, regulation, or related industry guidance affecting the types of consumer loans that you make. A consumer report, generally called a credit report, may contain inaccurate or incomplete information. The Fair Credit Reporting Act, or FCRA, and Regulation V govern the collection and reporting of credit information about consumers. However, the CARES Act placed important requirements on financial institutions that furnish information to credit bureaus about consumers affected by the COVID-19 pandemic. In this area, examiners found that many credit unions, i.e. those that furnish information about their members to one or more consumer reporting agencies for inclusion in the consumer report, violated the FCRA and Regulation V by failing to establish and implement adequate policies and procedures. The law requires a furnisher to establish and implement reasonable written policies and procedures regarding the accuracy and integrity of member information provided to a consumer reporting agency. The policies and procedures must be appropriate to the nature, size, complexity, and scope of each furnisher's activities. If you're a furnisher, you must consider the guidelines in Appendix E to Regulation V in developing your policies and procedures. You must incorporate those guidelines that are appropriate. Further, you must review your policies and procedures periodically and update them as necessary to ensure their continued effectiveness. In response to examiners' findings, the credit unions agreed to develop policies and procedures or to revise existing policies and procedures to implement the purpose of the Fair Credit Reporting Act. Some examiners also expanded their scope somewhat and found that one or more credit unions that furnished negative information about their members' accounts to a credit bureau violated the FCRA by failing to give account holders the one-time notice required by federal law. This notice must be provided to the consumer prior to or no later than 30 days after furnishing the negative information to a credit reporting agency. Appendix B to Regulation V includes 2 model notices. While you are not required to use the model notices, a credit union is deemed to be compliant with the FCRA notice requirement by properly using those in Appendix B. In response to examiners' findings, the credit unions agreed to provide their members with the one-time notice about reporting negative information to a credit bureau. If your credit union has violated any of the FCRA or Regulation V requirements, then you likely need to improve your compliance training and monitoring programs. This slide shows several resources available to assist you and your credit union. Thank you for your attention today. This concludes my part of the presentation, and I will now yield the mic to Matthew Nixon for a deeper dive into fair lending.
Thanks, Al. Good afternoon. My name is Matthew Nixon, and I work in the NCUA's Office of Consumer Financial Protection. Today, I'll discuss items NCUA considers when determining fair lending content for its consumer compliance exam scope activities. I will also discuss recent violations of the Equal Credit Opportunity Act we've noted where credit unions have discriminated against applicants or potential applicants based on their marital status or based on their age. We anticipate NCUA's consumer compliance exam scope activities will include a review of fair lending in risk-focused and small credit union examination program exams performed in federal credit unions. NCUA examiners will not complete fair lending reviews in state-chartered credit unions. The review will likely evaluate risk factors included in the Interagency Fair Lending Examination procedures and may include a review of appraisal bias. The Interagency Fair Lending Examination procedures categorize fair lending risks into 7 risk areas. Those 7 areas are shown on this slide. Federal banking regulators, including the NCUA, identify institutions with elevated fair lending risks by evaluating these risk factors. The NCUA's Office of Consumer Financial Protection, OCFP, allocates fair lending resources based on risk assessments such as these. OCFP's plan to evaluate risk factors included in the Interagency Fair Lending Examination procedures on a rotating and ongoing basis is shown on this slide. In 2021, NCUA examiners reviewed compliance program risk factors. In future years, the NCUA intends to review the remaining Interagency Fair Lending Examination procedures risk factors. These reviews will continue and eventually repeat to ensure NCUA is regularly assessing fair lending risks in federal credit unions. We encourage credit unions to download, review, and use the Interagency Fair Lending Examination procedures in their own fair lending compliance activities. Reviewing the procedures in advance of an NCUA examination should help you prepare for the fair lending review included in the exam. The procedures can also be a great resource to credit unions as they develop and implement their own fair lending compliance programs. You can access the procedures and its appendix using the links referenced on this slide. We included a discussion of marital status and age discrimination in our 2020 webinar. In fact, we have discussed marital status discrimination, age discrimination, or both in several public-facing presentations. We include the topic again this year because we continue to identify credit unions that are discriminating against their members or potential members in their loan programs based on applicants' marital status or age in violation of the Equal Credit Opportunity Act and its implementing regulation, Regulation B. I have 2 requests for attendees today. First, please review your lending programs to confirm your credit union is not engaging in the activities described today. Second, as you engage with your credit union counterparts at chapter meetings and other events, please consider mentioning that the NCUA has identified a number of marital status and age discrimination ECOA violations, and this issue remains a focus of NCUA fair lending exams. The NCUA would prefer that credit unions self-identify and self-correct violations rather than NCUA identifying those violations during its supervisory activities. Except as otherwise permitted or required by law, a creditor must evaluate married and unmarried applicants by the same standards. And in evaluating joint applicants, A creditor cannot treat applicants differently based on the existence, absence, or likelihood of a marital relationship between the parties. If, under a creditor's standards of creditworthiness, the personal liability of an additional party is necessary to support the credit requested, a creditor may request a cosigner, guarantor, endorser, or similar party. The applicant's spouse may serve as an additional party, but the creditor cannot require that the spouse be the additional party. A creditor may consider the marital status of an applicant or joint applicant for the purpose of ascertaining the creditor's rights and remedies applicable to the particular extension of credit. For example, in a secured transaction involving real property, a creditor can take into account whether state law gives the applicant's spouse an interest in the property being offered as collateral. If it does, a creditor may require the signature of the spouse on any instrument necessary under applicable state law to make the community property available to satisfy the debt in the event of default. A creditor's consideration of state property laws directly or indirectly affecting creditworthiness does not constitute unlawful discrimination under ECOA or Regulation B. When two applicants or signers are involved in a lending transaction, some credit unions are applying different pricing guidelines based solely on the applicant's or signer's marital status in violation of the Equal Credit Opportunity Act. For example, when two applicants are involved, some credit unions are pricing loans based on the higher of the two applicants' credit scores when they are married and based on the primary applicant's credit score when they are not married. A creditor may consider age or age-related information under certain circumstances. First, denying credit or refusing to consider an application because an applicant is not of legal age to enter into a binding contract is permissible under ECOA and Regulation B. Additionally, a creditor may favor an elderly applicant, defined as age 62 or older, in any system of evaluating creditworthiness. A creditor may use age as a predictive variable in an empirically derived, demonstrably and statistically sound credit scoring system as long as the age of an elderly applicant is not assigned a negative factor or value. And in a judgmental system of evaluating creditworthiness, age may be considered only for the purpose of determining a pertinent element of creditworthiness. And I'll elaborate on the last two bullet points in the next few slides. As I mentioned on the previous slide, a creditor may use age as a predictive variable in an empirically derived, demonstrably and statistically sound credit scoring system. I've included the definition of an empirically derived, demonstrably and statistically sound credit scoring system on this slide. In short, the credit scoring system must be developed using statistical methods. The system must be initially validated and periodically revalidated. A judgmental system of evaluating creditworthiness is any system not meeting the definition of empirically derived, demonstrably and statistically sound. In a judgmental system, a creditor may not deny an application or set the terms and conditions of credit based on age or information related exclusively to age. Age or age-related information may be considered only in evaluating other pertinent elements of creditworthiness that are drawn from the particular facts and circumstances concerning the applicant. Any such evaluation must be made in an individualized case-by-case manner. As an example, a creditor may not deny an application based on an applicant's age, but may consider the adequacy of any security offered when the term of the credit extension exceeds the life expectancy of the applicant. A credit union may not disqualify a loan applicant for automatic loan approval based on the applicant's age if the applicant is of legal age to enter into a binding contract. Such a practice violates ECOA and Regulation B even if the credit union subsequently approves the application following a manual review of the application file. Such a practice directly considers age in the credit union's evaluation of creditworthiness and does not meet any of the exceptions mentioned on the previous slides. Next, we would like to speak about two consumer compliance issues, appraisal bias and overdraft programs. The NCUA is participating on interagency initiatives to review possible inequities in the home appraisal process. Home ownership is a key building block of wealth. It is illegal to discriminate against someone because of race at any stage of the mortgage process, including property appraisals. When a home is improperly undervalued by an appraiser, it hurts the homeowner and the surrounding community. The overvaluation of a property is also problematic. Overvaluation can lead to higher rates of foreclosure. Ensuring the appraisals credit unions use to make lending decisions are accurate and free from bias is essential to a safe and sound mortgage lending process. Future NCUA examinations may seek to determine if credit unions have formal appraisal review processes to evaluate the consistency and accuracy of the appraisals they obtain. And now we'll go back to Ernestine.
Thank you, Matt. As Matt mentioned, another consumer compliance hot topic is overdraft payment programs. So overdraft payment programs continue to be an issue of concern. Our office has received consumer complaints regarding overdraft programs, and we are aware of several overdraft-related class action lawsuits against credit unions, mostly involving the practice of calculating the balance of a member's account for overdraft programs. We want to remind everyone that a credit union's overdraft protection programs must comply with all applicable federal and state laws and regulations, including laws on unfair, deceptive, and abusive acts or practices. Also, further, certain aspects of overdraft programs were an area of review in 2018, and at some point it might be appropriate to do a deeper dive into credit unions' policies and procedures governing its overdraft payment programs and practices. And lastly, and this is hot off the presses, today the CFPB issued 2 research reports regarding overdrafts. These reports contain information about overdraft payment programs in credit unions and banks. So, we encourage everyone to check out the CFPB's website and view a copy of the report. All righty. With that, I think that we are now at the question and answer portion of our presentation, and now it's time for us to answer some of your questions, and I'm going to pass this over to Joe Goldberg to facilitate this portion of the program. Thank you.
Thank you, Ernestine. I do have a number of questions that have come in, and we'll see how many of them we can get to in the time we have remaining. First question, I believe, is for Ernestine. The question is, you said that small servicers are not covered by the recent changes to Regulation X. Are small servicers exempt from all of Regulation X or only the new provisions? And while you answer that, we also got a second question, Ernestine, which is somebody would like to have you repeat the definition of small servicer.
Okay, perfect. So I will answer the question and then I will repeat the definition. All right, so small servicers are not exempt from coverage by all of Regulation X, but in addition to the temporary COVID-19 changes not applying to small servicers, there are some other Regulation X requirements that also do not apply to small servicers. And a good place to learn about the Regulation X requirements and the small servicer exemptions is in the CFPB Small Entity Compliance Guide on RESPA and TILA mortgage servicing rules. You can find this guide in the Mortgage Resources page of the Compliance Resources section of the CFPB's website. And their website is .gov. And now I'm going to go back and answer the question about a small servicer, the definition. And so the definition can be found in Regulation Z, and I'll give you the exact provision. It's 12 CFR 1026.41E4. So a small servicer, it includes a servicer that together with any affiliate services 5,000 or fewer mortgage loans for which the servicer or an affiliate is the creditor or assignee. Thank you.
Thank you, Ernestine. The next question is a fair lending question for Matt Nixon. Is the NCUA focusing its supervision efforts on the marital status and age discrimination issues discussed today?
Thanks, Joe. The NCUA employs various examination and supervision processes. For example, we have a risk-focused examination program. We have an examination program tailored for our smaller credit unions, and we also have a fair lending program. And I mention this to make the point that our supervisory focus is largely dependent on two factors, one being perceived risks, and the second, the type of supervisory activity we are performing. So credit unions that are scheduled for a fair lending exam or fair lending supervision contact should expect a review of the issues discussed today and likely other issues. Within our risk-focused and small credit union examination programs, NCUA examiners may review some fair lending matters, but when they do, it's generally at a high level. Back to you.
Thank you, Matt. All right, there's a question here, I guess, for Al Brantley to handle because it has to do with some of the matters that he discussed. Can you provide an example of what constituted inadequate policies and procedures and disclosures for loan forbearance or loan accommodations?
Yes, thank you, Joe. I'd be happy to handle that one. So let me qualify this. This is based on OCFP's observations. So an example would be the credit union offered relief or assistance to members because of a COVID-19 related hardship, but did not have uniform or standard procedures in place to ensure consistent practices. Staff relied on existing policy for guidance. Further, the credit union was not tracking requests from borrowers and was perhaps not coding the transactions in the core data processing system so that examiners could sample specific loans during their contacts. The skip a payment disclosures provided to borrowers may have indicated 1 month or 30 days of relief, while the credit union actually provided 2 months or 60 days of relief. So that would be an example of both combination of inadequate policies, procedures, and disclosures to the consumer. Back to you, Joe.
Great. Thank you, Al. And while you have the mic, I guess, there's a second question that I think is for you. Can the one-time FCRA notice be combined with other consumer disclosures, or must it be provided separately?
Good question. The notice, the FCRA notice, may be included on or with any notice of default, any billing statement, or any other materials provided to the consumer, and it must be clear and conspicuous. However, there is a caveat to bring to everyone's attention. If the notice is provided to the consumer prior to furnishing the negative information to a credit bureau, it may not be included with the initial disclosures that are required under the Truth in Lending Act, implemented by Regulation Z, for open-end home equity plans. So this is an important exception to keep in mind. Open-end home equity plans. Back to you, Joe.
Good. Thank you, Val. Next one for Ernestine. You mentioned that one provision of the temporary COVID-19 mortgage servicing rule ends on January 1st, 2022, but another provision ends on October 1st of 2022. Is that correct?
Yes, that is correct. As discussed, the temporary COVID-19 mortgage servicing final rule, it includes a number of provisions. So it's easy to kind of group these provisions into four components. So the foreclosure safeguards, these end on January 1st, 2022. You have the streamlined loan modification options. You have enhanced live contact requirements, and those are the provisions that end on October 1st, 2022, and also reasonable diligence requirements for servicers. So grouping the provisions, it makes it easier and kind of clearer for discussion purposes. However, we do encourage credit unions to really review the rule in its entirety to better understand the specific details of the rule and to help ensure compliance. Thank you.
Good. Thank you, Ernestine. Appreciate that. All right, here's one. I think I'll take this one. This question's about the new rule that allows credit unions to capitalize unpaid interest. Is there any guidance on how we determine that the member is able to repay the loan after interest is capitalized? The short answer is no. The NCUA board decided to give a credit union flexibility to make that determination as it chooses. When doing so, the credit union must have written policies that include the standards and the process for making that determination about the ability to repay. And the credit union must also retain the documentation showing how it made that determination every time it includes capitalization of unpaid interest in a modification or other similar loan accommodation. That's a good question. Thank you. Let's see. Another one for Matt Nixon. You mentioned in a judgmental system of evaluating creditworthiness, age-related information may be considered only in evaluating other pertinent elements of creditworthiness. What do you mean by pertinent element of creditworthiness?
Thank you, Joe. Reg B defines pertinent element of creditworthiness to mean any information about an applicant a creditor considers and that has a demonstrable relationship to a determination of creditworthiness. So, as an example, young people go through the process of establishing credit, right? We all do generally at some point in our lives. And until a track record of successfully paying creditors is established, applicants may be denied credit, they may be granted credit on less than favorable terms, or they may be required to provide a cosigner. So in that example, length of credit history could be considered a pertinent element of creditworthiness. Absence of a credit history may be correlated with a person's age, but the pertinent element of creditworthiness is not that a person is young. it is the lack of credit history and inability to demonstrate reduced credit risk. So pertinent element of creditworthiness considerations should be supported by institution or industry data. If the data supports, in our example, 24 months or 36 months, etc., as an appropriate length of time for an applicant to demonstrate a history of payment, then a credit union should not arbitrarily use a longer period in its evaluation process. Back to you, Joe.
Well, thank you, Matt. And while you're still warm, there's two related questions here. You indicated that the NCUA will not perform fair lending reviews in state chartered credit unions. Why not? And then the other related question is, are state chartered credit unions not subject to fair lending requirements? Or is it only that they are exempt from examination?
Yeah, let me take the second question first. So state chartered credit unions are subject to the same fair lending laws that other creditors are subject to. So they're subject to the Equal Credit Opportunity Act, Fair Housing Act, Home Mortgage Disclosure Act. We work with our state regulators when we determine what type of fair lending work we will do in a state chartered credit union. So we generally defer to the state regulator to perform those oversight functions. We make available our materials, our workbooks, when we develop our annual consumer compliance scope activities, and some state regulators choose to also use those. So when I say NCUA will not perform these functions, I don't mean to say that these functions won't be performed. And if we're talking about a fair lending exam specifically, while the NCUA generally does not independently schedule fair lending exams in state chartered credit unions, we do on occasion receive invitations from a state regulator to perform a fair lending review in conjunction with one of their exams. And so in those instances, there may be an NCUA examiner on site performing fair lending work, and that work would be rolled up and issued along with the state's examination report. Joe, back to you.
Okay, thank you, Matt. Ernestine, another one for you. Many of the pandemic-related protections had deadlines and have now come to an end. Is there an end date for the CARES Act amendments to the Fair Credit Reporting Act?
All right. So Section 4021 of the CARES Act, this is where the amendments to the Fair Credit Reporting Act are found. And these amendments require furnishers who provide a credit accommodation to a consumer affected by COVID to continue to report the consumer's account as current or as the status at the time the accommodation began. This provision basically, it helps ensure that consumers affected by the pandemic, that they can obtain essential relief without jeopardizing their credit scores and their future ability to obtain credit. So as outlined in the statute, this provision actually covers accommodations for consumers affected by COVID-19 between January 31st, 2020. And in the statute, it says the coverage period ends the later of 120 days after the date of enactment of the CARES Act, which would have been July 25th, 2020. As we know, that date is passed. So, or 120 days after the termination of the national COVID-19 emergency. So all that's to say is that that provision will end 120 days after the termination of the national COVID-19 emergency. Thank you.
Great, thank you. Matt Nixon, I'm going to go back to you. This is a question about one of the discrimination examples you discussed. Can you give some examples of pricing based on credit score violations when it comes to married and non-married co-borrowers? The quick person also has same household versus different household co-borrowers, but you can probably give a good response to this question.
Yeah. The key when we evaluate these items come down to, is the credit union using different standards for married joint applicants compared to unmarried joint applicants, or you could substitute signers. But basically, if it's the same type of request, the same type of application, and two parties are involved, are different standards being used? Is pricing different when you look at married, the two parties that are married versus the two parties that are not married? The same household, different household, that's a little trickier because we're talking about same household. You know, that's highly correlated with marital status, right? But it's not specifically evaluating a difference based on marital status. So if a credit union was pricing differently based on whether or not joint applicants lived in the same household or not, it could still be a fair lending problem. It still could lead to a fair lending violation, but it would be evaluated from a disparate impact perspective, whereas if it's explicitly married versus unmarried, that's disparate treatment. Joe, back to you.
Great, thank you, Matt. Another one for Ernestine, and this says, related to the Reg X provisions, do the COVID-19 mortgage servicing provisions only apply to Fannie and Freddie mortgages?
Okay. No, they apply not to just Fannie and Freddie Mac mortgages, but they apply more broadly to federally related mortgage loans, and this is defined by RESPA. So federally related it's an extremely broad category, but it covers most of the mortgage market. So this rule would apply even to servicers of non-federally backed mortgage loans, including loans that are held in private label securitization trust. Thank you.
Okay, I know that we're sort of planning to end the round now, and I think that this might be a good time to break. I think we've covered most of the substantive questions that have come in that we can address at this time. There are some others here that we may be able to answer at a later date and post them on our website if possible. So I think we'll try and do that. So with that, I want to thank everybody for attending. We had an extremely high number of attendees for this webinar. We appreciate everybody doing that. And I want to thank all the presenters who did an excellent job and give everybody back the rest of the afternoon. So thank you very much.